Good afternoon, good evening. We call to order our regular session of the West Valley City Council. We note that we have a quorum present. We believe that we have 6 members of the council here, all except for Councilman Rushton, and he will be joining us shortly. Oh, there he is. So everyone's here now. So let the record show that we have everyone here. Tonight we will begin our meeting with an opening ceremony under the direction of Councilmember Tom.
Thank you, Mayor. I appreciate it very much. I should invite all of you to stand up with me and do the pledge of allegiance. Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you.
Thank you very much. Next on our agenda, any special recognitions. It does not look like there are any scout troops here. Oh, but we do have a representative-elect here attending tonight, Fred Cox. Appreciate his interest in being here. Gearing up for the session to begin here in just, 2 weeks? 3 weeks. Fourth Monday. So, appreciate you being here tonight. Thank you for coming. Then we go to the minutes of December 9th and December 16th for our regular meeting. To the council then. Or not.
Mayor, I move for approval of the minutes of December 9th and December 16th.
We have a motion from Councilman Vincent to approve the minutes. Do we have a second?
Second.
Councilman Nordfeld has a second. The motion is properly before us. Any discussion to the minutes? Seeing none, we'll place it for a vote. All in favor of approving the minutes of December 9th and December 16th, please say aye.
Aye.
Those opposed say no. Motion passed unanimously. The minutes are approved. We now go to our public comment time. We have several individuals who have signed up to take a few moments. We simply remind those of you who will speak that your comments should be limited to 5 minutes, and I just want to get my timer up here just in case. Never know when someone might get long-winded. So with that, we'll just take them in the order that they signed up. And if I mispronounce your name, I apologize. I have to do 2 things, figure that out, and then also be able to read it, which I'm not great at. Jen Mascaro? Okay.
I've never done this before. So I have, I'm a real estate agent. We're working on multiple subjects.
If we would say, generally our requirement is name and address, and then if you're representing a group or something.
Okay. My name is Jennifer Mascaro. The address I'm here to speak about is 7058 West Beagley Lane in Beagley Estates in West Valley. I'm here representing a client. We have a property that's under contract we're getting ready to build a home on, and there's an issue with stucco. The subdivision's mainly a stucco subdivision, stucco and rock. And I guess recently you guys have passed a ordinance or something saying that they can only have hardy boards. It's pushing their purchase price. Well, there's 2 issues. It's pushing their purchase price up about $8,000 to go full hardy around the entire home. And they don't like hardy, so they're having to pay $8,000 extra for a home or for a product on their home that they don't want. So I'm just here to find out what the reasoning is behind that, and if there's any way that we can request a variance to have that changed. There are 5 lots in that subdivision, and it's actually pushing the sales price up to make it almost put it in a position where people can't afford the product that they want out there. We like to give them a big, nice house, and when you have a hardy board exterior that's costing significantly more, it just causes issues.
Thank you. Now, just for your information, it's not a debate kind of thing back and forth, so you're allowed to make your comments, and then we'll see if the council has any comments, but you can certainly check with staff.
Okay, yeah, and staff told us we had to come here and talk to you. We've been on the phone with your staff for over, what, 6 weeks now, going back and forth.
On these issues, what we would ask that if you would like to stay around until after our meeting, anyone has issues, you can do so and talk with our staff or us. But generally, during the meeting, we will not do an answer back and forth. The purpose of that is to maintain decorum and to have a standard format that everyone's familiar with, which you're not. So.
I'm not, I'm sorry.
Well, you're fine. Thank you very much.
Okay, thank you.
Mayor, I wanted to know, where was this subdivision located?
Beagley Estates is 7058 West, Beagley Lane, and it's approximately 6,400. I don't know, what is it, 60? No, it's 3,500. 2300 south. So right on the border.
Okay.
Thank you.
Next, we have Representative-elect Fred Cox.
Thank you, Mayor. My name is Fred Cox. I live at 4466 Early Duke Street in West Valley City. I noticed that you had added the prison on your agenda to possibly discuss, and I just thought I'd make a comment. And I can leave you a copy of this. I sent a letter to the PRC members questioning whether or not we moved the prison at all. As an architect, I used to work for an architect's office, and I worked on Gunnison, I worked on Oxbow. You can look at an aerial photo and you can see that there's enough room at Draper to double or triple the number of beds there. I called down to Gunnison. They're excited to have another 960 beds added if they can get them. We do not necessarily have to move Draper. One of the most important things that needs to happen is, I know that I spent 2 years going out to the Draper prison as a volunteer. It's very important that wherever the prison is located, that it's close to volunteers, to visitors, to medical, to courts, to a number of places, in a location where it's not ignored. We actually do not want individuals to stay in the prison forever. Generally, we want them to be able to come out and become good citizens. And so I have some concerns, but I also wanted to comment that I didn't have the opportunity to vote to move the prison a year ago, nor would I have. And there may be some other individuals that are having second thoughts. If it does move, I have talked to a number of individuals that are involved that do not like any of the 3 sites that are currently remaining. And I think it's very interesting. They had like 26 sites. They've opened that up for anybody else to turn in a proposal to the end of the month. But there were other sites that would have scored much higher with the new scoring system that they used for the final 6. And I've been in contact with at least one property owner or one proposal that feels like they didn't get a fair shot because of the fact that they were eliminated and then not given an opportunity of having their score recalculated. So I'm not as 100% sure that the prison will end up moving. What was voted on is that it would move sometime, somewhere, and whether that's 10 years or 3 years or 50 years, there are facilities out in the prison that I believe need to be replaced. I've stood in one of the Wasatch cell blocks with my wife while it was obviously occupied with guards and prisoners, and I know enough about prison design to know that that particular structure has got a very poor design as far as safety. But if you look at an aerial photo of it and also Gunnison, you can see a number of facilities that were designed in a more safe design, similar to, say, Oxbow or Gunnison, where you've got a pod design. I just want to pass on that if for some reason the prison were to move, it needs to be close to certain things, but it does not necessarily have to be it doesn't have to be one of the 3 locations, and it doesn't have to be in Salt Lake County. But I'm not sure that it really has to move anytime soon. I just thought I'd pass that on.
Thank you very much. Next, and I need to clarify here, Abdul Afridi, are you here to speak on the item on the agenda regarding your request? If so, item 7B on the agenda, or your application S-19 2014. If you are, there will be a separate public comment period for that. Okay, so if you'll reserve your comments for there. This is for everything else. Okay. So George Buys?
Yes, and I'm here with the same project.
Okay. So we'll get to those. We'll have an open public hearing on that in just a few moments. That concludes everyone who wanted to speak in our public comment period. And so next we turn to our city manager for any comments.
Thanks, Mayor. I'll just make a quick comment, hopefully to shed a little light or open up a little further discussion on the comments that Ms. Mascaro made, who I see still here in the audience. Thank you. And just wanted to first just make a comment. I'm sure that the staff didn't, intentionally direct Ms. Mascaro to come here before the council tonight, because as we know, this really isn't the form or the format to make any kind of changes happen along the lines of what she would like to happen. On the other hand, I also recognize that you're just trying to make and get some help with the situation, so no problem with that either as well. But having said that, what I will do is, of course, see if we can get further conversation happening between Ms. Mascaro and the staff there on the CED side. I'm fairly certain that probably what happened was they just weren't able to come to any kind of solution that both sides could work with there, and so probably a staff member said, look, this is how the council has defined the situation from an ordinance standpoint, and this is what it would take to change that. I'm sure that's kind of the vein in which that sort of conversation had, or if not, we can certainly have that conversation after as well. But anyway, to the point, we'll do what we can to help address that situation.
Okay, thank you. To the council for any comments. I would just make one. I'm excited to anyone that comes and speaks to us, because we don't often have them, unless we do chicken ordinances. So then we get a lot, but apart from that, it's pretty quiet. So thank you for coming. We always appreciate any input from the public. Then with that, that completes our comment period. Now we will begin our agenda items, beginning with 7. We note for you that these are items that we have previously discussed in another council meeting, and so we will be hearing or discussing these or not for the second time. And however, this was unusual in that we haven't had council meetings for the last 2 weeks because of the holidays. So it was actually a while ago that we had this, our last meeting. So with that, we now go to 7A regarding public input on the reopening of our fiscal 2004-2015 budget. This will be considering ordinance 1501. We have a number of items in our budget that were being modified, some new grants. Trying to think back, it's been too long. I didn't include a lot of it here. We did look, there were some new items, there were some contracts that we had previously discussed and voted on and passed in this body but needed to be officially incorporated into the resolution opening the budget. And so with that general introduction, Mr. Pala, any further items we ought to cover there?
No, I don't think so, Mayor.
Okay.
As you said, there's a variety of items that have been discussed.
But most of those are fairly routine, and so, and given, I don't think anyone's here, but we're going to find out. With that introduction then, I will now declare open the public input hearing on ordinance number 1501, opening of the West Valley City budget. So, is there anyone here to speak to this issue? Boy, no one here to talk about the budget. Boy, we'll have to go drum up some business one of these times. With that then, seeing no public input, we will close the public hearing portion of amending the budget for West Valley City. I declare that closed. We'll now come back to the council for any further comment or action. And if you're wondering why it's quiet, we've already had the discussion once before, and it seems that nothing has come up, no calls from citizens, so seeing no comment, Councilman Bueller.
I move for approval of ordinance 15-01.
We have a motion to approve ordinance 15-01. Do we have a second?
Second.
Councilman Hyun has the second. The motion is properly before us. Any further discussion? Seeing no further comment or discussion, we will place it for a vote. All in favor of approving ordinance number 1501, amending the budget of West Valley City for our current fiscal year, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. The ordinance is approved. We now go to application S-19-2014 regarding a plat amendment and a partial street vacation for a portion of Winton Street in the Chesterfield subdivision. This would be approximately 2516 South Winton Street. If you recall, when we discussed this, this is also creating a cul-de-sac. I believe that long-term plans imply that there might be a cemetery there. This will help you remember the discussion that we had there, and there needs to be, in order for access to be put in there, some changes in roads and then vacating of some items. So with that introduction, we will now declare open the public input portion regarding this application. So we would invite you to come forward, those who are interested, and speak to the council on this issue.
Hello, Mayor and Council. My name is Abdul Afridi. I'm the trustee of Islamic Society of Greater Salt Lake. My address is 9514 South Shellywood Circle, South Jordan, Utah, 84095. I want to thank the West Valley staff. It's several years we've been working on this project, and all of you are the council member and mayor, you've been in that area. It was a sore spot of the valley, and they had a bunch of chicken boxes, all kind of weird stuff, terrible dust, people were doing dirt biking, and Islamic Society approached the West Valley City to put a very peaceful and quiet place, which is a cemetery. And with that, we got a lot of help from the city. I mean, they were so kind. They have visited that site so many times. I think in the beginning, the neighbor had a little shock, but after they saw how beautiful it is coming, I think they're very pleased. So I just request all of you, inshallah, to get it approved, and let's move on to a really nice beautiful place. Thank you.
Okay, thank you very much. And I believe there was another gentleman here to speak on this.
No, he's the engineer, so.
Oh,
I'm just here for support.
oh, okay. Anyone else here to speak to this issue? Seeing none, then I will declare closed the public hearing portion on application S-19 2014. And come back to the council for comment or for action. To the council, Councilman Yun.
Thank you, Mayor. You don't mind if I have a couple of questions for you that you don't mind? Yeah, I do.
We would really need to reopen public.
Oh,
Yeah, I was looking at staff to say, would you wait just a second? Just while we clarify. Our rules require us to reopen that?
You know what, I'm blanking out here for a moment. I can't remember if we actually have to reopen it or if we can do it just by invitation at the council level. Reopen? Yeah, okay. Yes, so, Mayor.
So, in order to keep in compliance with rules, and that, because if we don't follow rules, someone perhaps could contest our action. Okay, so it is important that we follow state laws and rules regarding this. So, with that then, we will, with the council's, without objection, we will reopen the public hearing portion for application S-19 2014. Seeing no objections, I will reopen the public hearing portion, and we would invite Mr. Abdul Afridi to come forward, and we will go back to Councilman Hyun to ask his questions, and you can respond to them.
thank you, Mayor. Abdul Afidi, I appreciate very much your time to come here and to present this matter in front of us, and very dear and very close to our heart, Chesterfield. You live in South Jordan, Utah, correct? You did mention you live in South Jordan.
Yes.
Yes. Why you pick that area for a cemetery? Because it's close to the temple?
Oh yeah, we own 10 acres of land there. It's our mosque, our park, then we have future community center and the cemetery.
Okay.
Because our members are spread all over the area. We have over 30,000 community. We live in South Jordan and Sandy, different places, but that is our center.
Okay.
Yeah.
And the next question I'm gonna ask you is, so the ownership is a individual or just the group of people?
It's owned by the Islamic Society of Greater Salt Lake.
Okay, thank you so much.
Thank you.
Is that all? Any other questions for Mr. Afridi, or? If not, thank you very much.
Yeah.
And now we will declare closed the public hearing portion on this application. With that, we now come back to the council for any further comment, discussion, or action. Councilman Bueller.
Thank you, Mayor. I just want to clarify with staff, it has been a few weeks since we met and reviewed this. A cemetery or not a cemetery is a permitted use. We're not voting on whether there would be a cemetery on this land, just whether we would change the subdivision plat. Is that correct?
That's correct, yes.
And the cemetery itself, whether it's built or not, and what governs the placement and operation of a cemetery is under the health department, not the city.
And I'll have to refer back for answer to that.
Yes, sir.
Okay.
Thank you.
Thank you. Councilman Young.
Thank you, Mayor. To follow up with my colleagues here, Steve Bueller, I believe we have a couple of questions for our staff, Steve Lehman, about the culture and also environmental in that area. Is that this, you have the answer for us?
Staff are allowed to participate.
Yes.
That's not a public hearing. That's an internal discussion. you're actually answering the question for Mr. Pyle, who is a member of the council, not a voting member, but he can discuss and his staff can participate.
My name is Steve Lehman. I'm the current planning manager with the Planning and Zoning Division of the city. During the study session of the City Council on the 16th of December, there were a number of questions related to the cemetery itself. I'll see if I can recall those. Groundwater was one of the questions, whether the cemetery would be impacted by groundwater. In 2013, a firm, IGES, did a study and found that groundwater was encountered 5.5 to 6.5 feet below the surface. Because the site will be raised 2 to 3 feet for grading and drainage purposes, as well as the connection with the cul-de-sac, groundwater will be 7.5 to 9.5 feet below what will be the finished grade. So groundwater should not be a problem for the cemetery. In addition, after talking with Mr. Afridi, each of the cemetery plots will have a concrete vault, so that will also be an added measure of protection if groundwater does elevate. Landscaping and maintenance comes to mind as well. In talking with the Islamic Society, there is an endowment fund that will be set up. The sale of the plots, in addition to other fundraising efforts, will generate a fairly substantial amount of money to help for the perpetual maintenance of the cemetery with water, landscaping, maintenance of their building, etc. Other issues were mentioned by Councilman Hune. The way that the bodies are placed in the ground does not involve embalming. Once the mortuary certifies the death, they bring the body to the cemetery site or to the mosque site. There is a short service in the parking lot. The body is then delivered to the cemetery for burial. Generally within 24 hours is the standard practice for this group. Those are the questions that I recall off the top of my mind, unless you have others that we can answer for you.
Yes. You mentioned about the waters underground. It's about 7 feet underground, correct? But do you know that the flood area, Chesterfield is the flood area?
Yeah, generally speaking, the elevation of the flood or a floodplain certificate is typically used for habitable structures. So to our knowledge, we do not have any concerns with regards to groundwater itself. It may be in a floodplain, but those are generally relegated to habitable structures for living individual homes.
So include, we have anyone living at Chesterfield, they have to buy the flood insurance, including me. My family have to buy the flood insurance.
Yeah.
So what is that telling us?
Well, once again,
in the past we have the floods there, correct?
I'm not sure, at least in my time here, I do not know about flooding in Chesterfield, so I can't address that question. I'm not sure if Public Works may have an answer, but in my time here, I'm not familiar with it.
But that requirement in our area at Chesterfield have to buy the flood insurance.
I believe that is a standard requirement if you are in a floodplain. Probably your lender would require that. I doubt that they would need that type of insurance for a cemetery, but I'm not sure.
The discussion has kind of changed, and we're discussing the cemetery, which actually we're not going to vote on tonight. And we don't have any authority to vote on, and whether that becomes a cemetery or not is an interesting issue, but is not the issue before us. So perhaps we should steer back to the issue before us, which is the approval of this particular request on vacating a part of the street and amending some lots. Okay? And we can have that discussion in the future, but and just to clarify that, Mr. Pyle, am I making the correct statement?
Yeah, yes, I think that's correct, Mayor, so I would support that. I would also say to Mr. Hune or also any of the other council members, if you have questions specific to cemetery development generally, or this one specifically as well, although we know that's not the the question for approval tonight. We also believe and understand that is the intent. We'd be glad to do that as well too. We'll work with you and provide any information you'd like outside of this venue as well.
Certainly we can and will. We encourage staff to do that as you have questions to coordinate with that.
Yeah, the reason I mentioned that about because our staff brought up about certain people, you know, the underground water, and I'm concerned about the floods. That's how to respond back to the staff. Yeah, we have to buy a flood insurance in that area. We have to that requirement from that particular area.
Okay, thank you. Then continuing our discussion of the approval of this particular ordinance, 15-02, or application S19-2014. Councilman Vincent.
Mayor, I move for approval of ordinance 1502.
We have a motion to approve. That's proper.
Second.
Councilwoman Lang has the second on it. The motion is properly before us. With that motion before us, do we have any further discussion? Councilman Hyun.
I vote no for this one. I'm approved for this. If you can count, and I will say nay. But that's the reason, because I don't feel that the particular property will have a cemetery there. I'm concerned about this cemetery. Is kind of hidden away from everything. It's kind of like environmental problem, and also it's no connection with the people. They have family members they bury in that area, and I know it's the trustee. However, I'm concerned about, I mentioned earlier, that's a flood area that they require every single family in that area have to buy a flood insurance. And I know that our staff have brought it up about 7 feet underground, but I'm very concerned about that. And so the environmental problem that I'm concerned.
Thank you. Any other? Councilman Rushton.
I would just say that I appreciate Councilmember Hugh's concerns on this. He represents the area and knows it intimately, and I would say that you know that the requirements of a cemetery are probably pretty lengthy and long, and glad that there's state agencies and that will work along with our city agencies to make sure all those requirements are met, especially in a floodplain with the river coming by. But I am confident enough that our city staff and the state agencies will make sure that if a cemetery is the ultimate use for this, that it will be done in a good and manner that's not only an addition to the neighborhood, but it would meet any health or environmental impacts. But also just that I think the statements by Mr. Friddy at the start were very good, that you know, their main goal for amending these lots and vacating the cul-de-sac is for the overall improvement of the area, which I think it will do, and will cause me to vote and urge affirmative vote on this one.
Thank you. I would add some comments. Of course, there's a fair amount of state law as well governing cemeteries, and I'm sure that those will have to be met and all requirements will be taken care of. And as I looked around, in fact, one of the questions I received going door to door from 2 people, of course they knew each other, was why the city didn't have their own cemetery. And of course the reason for that is we have private ones. However, cemeteries are a positive thing in cities for families and for organizations as well. And so I think it will add a lot to our city and certainly to that area compared with what was there before. So thank you very much. Seeing no further hands or comments, let's put ordinance 15-02, amending lots in the Chesterfield subdivision, including a partial street vacation on a portion of Winton Street for a vote. Those in favor of approving that ordinance, please say aye.
Aye.
Those opposed say no. This is when you have to officially say it. The other was just talking about it. Okay.
No.
Okay, so the resolution passes 6-1 with Councilman Yun voting in opposition. The motion passes, the ordinance is approved. Next we go to our resolutions, item number 8 on our agenda. We'll begin with item 1501, resolution 1501, changing the trustee on the city's life insurance policy with Western Reserve Life. This was an unusual and old thing. It is a technical change. The original life insurance policy and the way it was set up such that in order to change a beneficiary, it had to come to the council for approval. That's kind of cumbersome. We don't do that anymore. I think this is kind of a unique one. But given that that was the situation, this resolution will allow this individual who retired, who used to work for the city but now works for Layton, well, he did, now he's retired, to be able to change the beneficiary there. And so with that introduction, we go to the council now for discussion or action. Councilman Nordfeld.
Mayor, I move for approval of Resolution 1501.
Second.
We have a motion from Councilman Nordfeld. We have a second from Councilman Vincent. Motion is properly before us. Any discussion to this motion? Seeing none, we'll place it for a vote. All in favor of approving Resolution 1501, changing the trustee on the city's life insurance policy, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. The resolution is approved. We now go to Resolution 15-02, and again we remind you these are things that we have discussed before, so this is the final hearing and review on it. Approving a right-of-way agreement with Eldorado Investment Company for property at 4899 West, 2100 South, and to accept a special warranty deed and storm drain easement. And this is on that roadway that we've been discussing, and we'll discuss again next week, these little pieces we all have to put together for that 2400 South approximately road. And with that, we'll turn to the council now for action or comment. Councilwoman Lang.
Mayor, I move for approval of Resolution 15-02.
We have a motion to approve. Do we have a second?
I'll second that.
Councilman Rushton is the second. The motion is properly before us. Any further discussion? Seeing none, we'll place that for a vote. All in favor of approving the right-of-way agreement and accepting a special warranty deed and storm drain easement on property at 4899 West, 2100 South, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. The resolution is approved. We now go to Resolution 15-03. This is again a right-of-way agreement with Eldorado Investment Company, 4899 West, 2100 South, and again a special warranty deed and storm drain easement. Same situation here. The funds for these are coming from state funds that were allocated for this specific purpose. And so with that introduction, we'll go to the council. This is to complete portions of that road for your action or comment. Councilman Vincent.
Mayor, move for approval of what are we doing? Resolutions 1503.
Second.
Okay, we have the motion before us and the second, Councilman Rushton. It's properly before us. Any further discussion? Most of these are fairly routine. We're putting in a road and we're picking up small pieces of land associated with it for and getting certain easements and storm drains in place for that road. And we will continue to do this probably for a few more council sessions. Those in favor of approving then Resolution 15-03 for this right-of-way warranty deed and storm drain easement, please say aye.
Aye.
And those opposed say no. Motion passes unanimously. The resolution is approved. Now we go to Resolution 15-04. This one is also with Eldorado Investment, but at 5065 West 2100 South, excuse me. And is a right-of-way agreement and a special warranty deed. Again, on that same road or concept, it curves around. So with that, to the council for any action or comment. Councilwoman Lang.
Mayor, I move for approval of Resolution 1504.
We have a motion to approve. We have a second from Councilman Nordfeld. Motion is before us. Any further discussion? Seeing none, we'll place the motion for a vote. All in favor of approving Resolution 15-04, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. The resolution is approved. We now go to 15-05. This is also with Eldorado Investment. Same thing, right-of-way agreement and a special warranty deed. Property at 4901 West, 2100 South. Same situation, same road, same purpose. To the council.
Motion to approve Resolution 15-05.
Councilman Yun has a motion to approve. We have a second.
Second.
Councilman Vincent has a second. We have the motion properly before us. Any further discussion? Look both ways before I cross the road. Then all in favor of approving Resolution 15-05 for this right-of-way agreement and special warranty deed, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. The resolution is approved. We now go to Resolution 15-06, a special warranty deed, now from TYP Company for a portion of property at 4071 South, 4000 West. This one is just slightly different, or get down to my right page, see if there's anything I missed on there. And I must have missed it since I went too far. Don't have it. Just a different location, I believe. Same type of concept, I believe, again, for a roadway. So with that introduction, any further, well, we turn it to the council for any action or comment. Councilwoman Lang.
Mayor, I move for approval of Resolution 15-06.
We have a motion to approve that Resolution 1506. We have a second.
Second.
Councilman Vincent has a second. Motion is properly before us. Any further discussion? Seeing none, we'll place it for a vote. All in favor of approving Resolution 1506, accepting a special warranty deed for property at 4071 South, 4000 West, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. The resolution is approved. And now I'll take a breath. No. We now come to item G on our agenda, 8G, Resolution 15-13. This is a resolution to oppose the relocation of the Utah State Prison to a proposed location at approximately Interstate 80 and 7200 West. This was recently added to our agenda, but in plenty of time for it to be shared with the public. That is the resolution that's before us. We had some discussion on this in our previous meeting. So we did have some discussion just a while ago in our study meeting, but now it is before us here to the council for comment or action. okay with silence. Now, a clarification from Mr. Pyle on policy here. If we take no action or just decide not to do anything and move to the next item on our agenda, what becomes of the item? Does it reappear on our next agenda?
If no action were to be taken whatsoever, Mayor, then it would just fail for lack of action. We would not bring it back.
Okay. So I'll give it another quiet moment. Oh,
It's a bill.
Councilman Bueller.
May I ask a question?
Certainly, that is in order.
However, if we took no action on this, it wouldn't preclude staff from bringing a similar resolution at some point in the future. Is that
That's also correct, sir, yes.
So, Councilman Reston.
You know, as much as I would like to proceed with this resolution, I think we found out in our study meeting and that it's a very fluent and dynamic topic, moving target that moves every day, and that we're probably not quite ready to address this. So I would just move that we remove Resolution 15-13 from our agenda tonight.
That motion is ordered. Do we have a second?
Second.
Seconded by Councilman Vincent. That motion is properly before us. Any further discussion? Seeing none, we'll place it for a vote. All in favor of taking it off our agenda tonight, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. It's off of the agenda. We now move to item number 9. This is to hear and consider an appeal of the city manager's denial of a grandma request from Nate Carlisle of the Salt Lake Tribune. And I believe we have a lot of information on that we discussed a few weeks ago. Now on this, because this is a little different process, an appeal of a grandma request, my understanding is we are going to hear from the individual involved.
Yes, sir. In fact, it would be helpful, normally what we do when we've had these requests come before us or these actions is, and in fact I would recommend this, so usually we'll give the city attorney a couple minutes just to outline the process and why it's set up the way it is, and then let the procedure go from there, Mayor, if that would be okay.
That's perfectly fine. Since this is a new one for me, I've only been here a year, so I haven't seen everything. So, Councilman Rustin.
I think I would just add that it might be good to just maybe set up a procedure, what to expect with, you know, we hear from our city attorney first, and then from the applicant, and then the response, and then a rebuttal, and another potential rebuttal.
Yeah, and in fact, that's what the city attorney will do, sir, is he'll actually tell you how that procedure will move forward.
And as it is outlined by our city attorney, we will follow that procedure, and staff will assist me if I don't get every step correct. We do want to do it right.
Absolutely. So with that, I'll invite Mr. Bunderson to the podium.
Thank you, sirs, Mayor and Council. As we discussed a couple weeks ago, I know it's been a while, so it's good to have this refresher. This is the council acting in their quasi-judicial role. You'll be hearing an appeal from Nate Carlisle with the Tribune, who's here, and you'll be deciding whether or not to uphold City Manager Pyle's decision. The actual procedure is found in 3-16-502 of the West Valley City Code, which mirrors the state code almost word for word. The important part to you is all the preliminary stuff has already happened. Is that it reads as follows: at the hearing, the City Council shall allow the parties to testify, present evidence, and comment on the issues. City Council may allow other interested persons to comment on the issues, although I don't believe you'll have any of those here tonight. So my counsel to you, counsel, is that you allow the moving party, which is Mr. Carlisle, to go first and to present his argument. Allow the city, represented by Ms. Stonebrook, to rebut, and then to respond. Allow Mr. Carlisle to rebut that, and then if there's more beyond that, you can certainly go ahead and do that. But that usually does the trick, to have the three sort of speakers like that, and you can ask them whatever questions you want, and I will stand by as your counsel to answer questions now or later when you want to deliberate. I also have the documents at issue, and if the council wishes, the council may look at those in camera, which means without either of the other parties looking at them.
Just a clarification, at what point do we check to see if there are other people here to speak to this issue?
You could do it now, or you could do it after after the two parties have had their
let's do that at that point. Okay. A question, Councilman Rustin.
This afternoon we received an email regarding this. I believe it was from Mr. Carlisle. And I don't know if everyone's had a chance to look at it or review it, but I wondered if we could have it available, or even if it was a PowerPoint thing, so if we could have it out, or just, I'm assuming he's going to refer to certain things on it, so we can have that made available.
Yep, Jake's ready to present that when Mr. Carlisle's ready.
Okay. Mr. Pyle?
Thank you, sir. Just for the benefit of the audience and also as a refresher for the council as well, could you take a sec, Mr. Bunderson, and just go over how the decision of the council will be made?
Sure. The council, after they hear all the evidence, is required to make a decision in 5 days, 5 business days. So we've always counted that as being the next Wednesday, so a week from tomorrow. And so the deliberation process happens after the hearing, usually, unless it's an issue. I believe in the past we have had a couple times where the council just wants to deliberate openly and vote from the bench, which they absolutely can do. I'll just follow up with a written decision. But if you do need some more time to deliberate, we will meet in private, and you're allowed to deliberate in private because, again, this is your quasi-judicial role, and so this isn't in your role as legislators, so to speak, but in your role as judges. So you can go ahead and meet in private, deliberate, call on me for any assistance or counsel that you need, and then we can announce the decision next Tuesday after the hearing, by next Wednesday at the latest.
Anything further from the council? If not, all right, then. I believe next is Mr. Salmon? No. Carlisle. Okay. Oh, excuse me, I'm looking. Sorry, I'm reading the wrong script. Tribune records here.
I've made that mistake before, too. Thank you all very much. I am Nate Carlisle from the Salt Lake Tribune, and before I get started, I'd like to thank city staff, including Ms. McKendrick and Mr. Bunderson, for helping me follow the proper protocols so I could address you here tonight. I also want to thank Ms. Stonebrook and Mr. Pyle. There are denials, and then there are articulate denials, and you are in the latter, and it will help us all make an intelligent, have an intelligent conversation here tonight. And lastly, thank you to the gentleman who just told me how to work the PowerPoint presentation. I appreciate that as well. So I'm going to speak to you tonight about some precedent that I think is relevant here to help you make your decision. Both judicial precedent and what some other municipalities and political subdivisions have done in Utah when we have sought similar documents. But let me begin. This is a clarification of what I am actually seeking. This is taken from my appeal to Mr. Pyle. I am specifically asking for the internal affairs files related to Kevin Salmon and a recording or transcript of all of Mr. Salmon's interviews concerning the events of November 2, 2012. My original request was broader, and the city provided some relevant documents. In a couple other cases, they said there were no responsive documents. The appeal here tonight simply addresses those documents which are responsive, but the city feels are not public record. Okay, and now this is really embarrassing. I found an error on this page as I was sitting waiting for this hearing, but I'll get to that in a moment. First, Ms. Stoneberg cited 63G2-302 subparagraphs 2 and D, and also chapters 305 subparagraphs 10A and B. And let me start with 302. This is the chapter that deals with private records in the state of Utah, and here's where I made an error. I cited the wrong subchapter. However, thanks to, again, Ms. Stoneberg's articulate denial earlier, I have a copy here of what that chapter reads. It says it makes non-public, or I should say, pardon me, it makes private records containing date on individuals, this disclosure of which constitutes a clearly unwarranted invasion of personal privacy. So in other words, Ms. Stoneberg and Mr. Pyle, through his denial of my appeal, are arguing that these are private records and it would constitute a clearly unwarranted invasion of personal privacy. And then down to with 305.10, and that, again, this is A and B. I think the auto subparagraph function of PowerPoint got me here. So that should be A and B underneath 305. It talks about the category of protected records. Protected is technically considered non-public, but it allows for some records to be made public based on the specific classification. But here, the city has felt these are non-public records because they could reasonably interfere with investigations undertaken for enforcement, discipline, licensing, certification, or registration purposes, or reasonably could be expected to interfere with audits, disciplinary, or enforcement proceedings. However, this matter has been addressed before, and it was addressed in a very significant Utah Supreme Court case. This was called the Deseret News Publishing Company v. Salt Lake County, and it was ruled on by the Utah Supreme Court in 2008. And there are lots of similarities between this case and what we're talking about here tonight. The Salt Lake County Clerk's Office had done an investigation into sexual harassment in that office. They completed a report on what occurred, and then they did not want to release it. They argued that they had already classified the record as protected and private. The Supreme Court looked at this and said that both the county and the trial court had erred. First of all, it said that the trial court owed no deference to the county's pre-classification. The trial court should have looked at this de novo. For those of you here who are an attorney, that means take a fresh look at it. And the trial court did not do that, and it should have. But then it also said that Salt Lake County had failed to adequately demonstrate, first, that this was a protected record, because they said there was no ongoing investigation. And my understanding of Mr. Salmon's status here is that there is no ongoing investigation. He has resigned. The district attorney declined to prosecute anything. West Valley City, as I understand it, has stopped its investigation into Mr. Salmon. The Utah Supreme Court in the Deseret News decision also said that the release of that report was not a clearly unwarranted invasion of personal privacy because it dealt with public officials and their official capacity. And as such, there was a public interest best served by the release of the report because it discussed that performance of a public official in the discharge of his or her duties. Now, I sent a copy, or I should say a link to the Utah Supreme Court opinion. It was what I sent, including what I sent Ms. McKendrick today. You're welcome in your deliberations to read the entire ruling. As you might imagine, I've just summarized it here for you. Now I want to talk about a second case that was addressed in the judiciary. This one was more recent. It was the case of Jeffrey B. Lawrence, the Utah Department of Public Safety. Utah Department of Public Safety here is the umbrella organization under which the Utah Highway Patrol sits, and UHP was really the agency at issue here. Mr. Lawrence had filed a complaint about a state trooper, and UHP never told him the outcome of that complaint. And Mr. Lawrence filed a ground bar request. Ground bar requests were denied. This is where the State Records Committee actually ruled in UHP's favor. And here in 3rd District Court, Judge L.A. Dever overturned the State Records Committee and ordered the release of the report. And the argument here was not entirely the one that the city is making with Mr. Salmon. There was, according to Judge Dever's ruling, there was no discussion of the protected status, instead focused on the private classification at 302A in a similar another subparagraph in that section, section D. But again, Judge Dever ruled that the investigative record, this is a quoting here, quote, investigative records addressing alleged violations of the public trust fall outside of this section because they are not the same kind, class, character, or nature as the specifically enumerated categories of sensitive personal information identified as, quoting within the quote, performance evaluations and personal status information such as race, religion, or disabilities, close all quotes. And Judge Dever also said that DPS UHP failed to show the release of their investigative records would result in an unwarranted invasion of personal privacy. So that's the judicial precedent here. Let me just talk a little bit about what other political subdivisions of the state of Utah do. In recent years, the Tribune has obtained copies of the following following investigations undertaken by cities, counties, or state agencies into their own employees. This is another term for internal investigations. You've heard about some of these in the news. There was the University of Utah released a report about troubles with a swim coach and troubles at a fertility clinic. I've gotten a report from Roy Police Department about misconduct it found by its police chief. Also, Ogden released a report on the, I think it was 2012 shootout that wounded 5 police officers and killed 1. And that report laid out some of the errors those police officers made leading up to that shootout. Finally, I'd like you to consider some equity and transparency issues here. We know that 7 officers in the Neighborhood Narcotics Unit were disciplined and 1 was terminated over some problems found in there. We know the transgressions the city... However, with Mr. Salmon, the city is saying, we can't tell you what we found, simply, it seems, because he quit. And because he quit, he wasn't disciplined. I find something inequitable there. It's like the other people are being punished because they stuck around. Also, Mr. Salmon was on paid leave for about 23 months while he was being investigated. He was being paid that entire time. The city was investigating him for large parts of that time. I think it's reasonable that we find out what the city found in all that time. That concludes my presentation. I'll take questions at this time, or I'll yield to Ms. Stonebrook, whatever you prefer.
Any questions for Mr. Carlisle from the council? Are we going to wait till we hear the other? Okay. Thank you. Ms. Stonebrook.
Thank you, Mr. Carlisle. Thank you, Mayor and Council. My name is Martha Stonebrook. I'm the Public Safety Attorney for West Valley City. And thank you for listening to me now. The city has properly classified the interviews and files that Mr. Carlisle has requested. He requested those based on investigations and interviews about the November 2nd, 2012 incident. We classified that, as he pointed out, under 63G230510A and B. That is because it offers protection for records that really are undertaken for disciplinary or investigative purposes if that disclosure could reasonably be expected to interfere with those investigations and proceedings. Mr. Salmon resigned from West Valley prior to West Valley City completing the investigation into the events of November 2nd, 2012. No discipline was issued because, of course, that investigation was not completed, and so that in itself would indicate that that is not a complete investigation. There is nothing that completed that file. That makes it different than the Deseret News case that Mr. Carlisle mentioned. In that case, the decision had been rendered, a formal investigative report had been filed, and really the matter was closed. But Grandma does anticipate that if matters can be made public, if in fact discipline has issued and all of the times for appeal have run. Well, here the file was not even completed. The reason that it could impact the investigations and could compromise that to release files such as this of an incomplete investigation, it would allow all kinds of speculation and conjecture as to whether or not the officer or any other public employee actually did what he or she was alleged to have done, and whether or not some policy may or may not have been violated. That again separates it from the Deseret News case. That was signed, sealed, and delivered. There wasn't going to be rampant speculation as to unfinished business, just charges. Anyone can allege anything about any employee, any public officer. That doesn't mean that those allegations are sufficient and that they have been sustained. So the matter here involves the officer-involved shooting. That's the November 2nd, 2012 incident that Mr. Carlisle related his request to. Mr. Salmon was interviewed as part of that shooting investigation. The reason, of course, he was on leave for such a period of time was because that became a drawn-out process while criminal concerns were being addressed by the district attorney, things that were out of West Valley City's hands. And so to make an officer's statement public prior to a final determination of a shooting investigation can definitely impact those types of investigations. It could compromise the integrity of the investigation, but it also could make it very difficult on an officer who's been involved in a terribly stressful situation if he believes that his statement's going to be made public without the benefit of a full and fair investigation. Here, Mr. Carlisle has specifically requested the interviews of Mr. Salmon concerning November 2nd. There were 2 of those, and both should be well within the protected category that we have stated. Because the first one was getting an officer statement concerning a shooting. The next time there was an interview, that was not a West Valley City investigation. That was conducted at the behest of one or more federal agencies during its investigation into the November 2nd, 2012 incident and other things not known to us. And so the city has not been informed of the status of that federal investigation. And so certainly for West Valley City to give over an interview that was taken incident to that investigation, that we do not know that the status of it is unknown to us to this day, could certainly compromise not only that investigation, should it still be continuing, but others if agencies could not rely on West Valley City to keep things that are part of a completely different investigation from becoming public when it really is not ours to choose there. As for Judge Devers' ruling, it does not have binding precedent on you to make your decision. While yes, it talked about the clearly unwarranted invasion of privacy, and we certainly feel that we had chosen that private classification as apt in this point on the reason that an officer who has been given a statement on a shooting, yet that matter has not yet been finally resolved, certainly would feel an unwarranted invasion of privacy should that be released. But what the Judge Devers ruling never spoke to was the protected classification of investigation and disciplinary type records. That was not addressed. Nothing about 30510A or B was mentioned in Judge Devers' ruling. And if you read the Records Appeal Board, their decision, Department of Public Safety did not raise that as one of their reasons for denial. So the matter of a protected record under 30510A and B was not even before Judge Devers. So that's an additional reason to not feel bound in any way by his decision. The Department of Public Safety had argued that it was basically a personnel record and or it was protected by the attorney-client privilege. If you will read our denial letter, you will see that we did not choose either one of those. And as far as what other agencies do, what other people do when they have received a grandma request, Mr. Carlisle put up a few incidents of documents that he has gleaned from other agencies when he has requested that. We didn't see the grandma requests. We are not bound to all classify everything the same way. The grandma statute anticipates that there is not an automatic classification where there's just only one response. It requires the entity that has those records to look seriously at it and make their determinations on a case-by-case basis. That was one of the problems that the court found in the Deseret News case. They just closed their eyes and said, any investigation into things like that, we're never giving. Well, that fails to take into account the various issues and make a decision. We did not just close our eyes and deny Mr. Carlisle's requests. We looked at them not as just one single request, uh-oh, you can't have anything. We gave him the things that we felt we could and should, and we did. And so here, to give over files that have not been completed, to give over investigations, interviews that were at the behest of government agencies in the federal government for an investigation, the conclusion of which or the findings of which have not been shared with us, would have a chilling effect going forward. It would be reasonably expected to interfere with these types of things. And grandma lets you choose these things wisely. It lets you make these determinations on a case-by-case basis. It also, the grandma statute, also allows, certainly for the appeals such as this one, the reason that we're here, it also sets forth the evidentiary standards for release of certain records. It gives guidance to the various levels of review. And in the grandma statute 63G24061, it states that a record, any records that have been classified at the initial level, such as we did, as protected under 63G2305010, those are those investigative records, in question have been classified, then an order requiring the release of those records can only be made if the party seeking the disclosure and here that would be Mr. Carlisle, has established by a preponderance of the evidence that the public interest favoring access in those records is equal to or greater than the interest favoring restriction of these documents when in fact those investigations have not been finalized. And with all due respect to my friend Mr. Carlisle, I do not believe in this case that he has met that burden. He has not shown that. And we believe that Mr. Pyle's decision, his letter stating the reasons why he upheld our classification and denied that interim appeal should be reread. You should look at that, and we would request that you would uphold that and not allow the release of these records.
Does that complete your comments?
It does, unless you have questions for me.
To the council then, and it looks like we're going to have some questions.
Yes.
Councilman Young.
Yes, sir.
Thank you, Mayor. Ms. Stonebrook, I appreciate you coming here tonight and trying to explain to us about the fire of Mr. Salmon. Here, a question I want to ask you is, you were sharing with us this case is not complete investigation, correct?
It is not a complete investigation. Yes, that's right, sir.
How long you think you're gonna complete this file?
He has resigned, and so there would not be any action we could take with respect to Mr. Salmon. So that matter has simply been suspended. Both individuals have left the employ of West Valley City that were involved in that November 2nd, 2012 incident.
Okay, so that leads to me another question I'm going to ask you. So I mean, this case is not going to release in public.
That's right. It would not be a public record where, say, if he had received a disciplinary letter or something, the grandma provisions indicate that those are public. And in fact, we have released the letters of discipline and what have you with respect to the people who Mr. Carlisle mentioned had received discipline in the NNU matter. But that is not this, that's not the shooting.
Okay, thank you.
Councilman Bueller.
Thank you, Mayor. First I have a question for Mr. Bunderson.
Oh.
Mr. Bunderson, these documents, will they not be subject to discovery in any civil lawsuit?
I guess it would, Eric Bunderson, the city attorney, I guess it would depend on the particular lawsuit. The documents that we're discussing have been released as discovery. Some of the documents have been released as discovery in some of our civil cases. Some of them have not.
Then I think we need a list of what documents there are. I've heard an internal affairs file, and I've heard of 2 interviews, which I assume are included in the internal affairs file. So could we get a list of what documents we're talking about?
Absolutely. Either myself or Ms. Stonebrook, I believe, can answer that. Whoever you'd like.
I mean, if there are various documents in a file or interviews, or, you know, what are they? I'm ready to write them down.
All right. The internal affairs file into the shooting has not been, as I say, completed. It was...
Well, but it's not going to be completed.
No, but as I say, so there would be the district attorney's ruling, the district attorney's letter.
And let me stop you there. Hasn't that already been made public?
Yes, and I believe that we've given that to the press and
so
Mr. Carlisle, but he didn't, yeah.
Document number 1, what's document number 2 we're talking about?
There would have been an adjudication by a deputy chief giving his advice or recommendation, if you will, acting as an advisor to the chief.
And that's a West Valley City Deputy Chief of Police?
Yes, sir, it is.
That has not been made public yet?
No.
Okay, and what's next?
There is I believe there is the one interview.
An interview conducted by our department?
It was in conjunction with the officers giving their statement. It was not conducted here by Internal Affairs. It was conducted with the at the 2 police officers' attorneys' offices. So, but yes, we do have a copy of that.
Who conducted that interview?
The investigator for the attorneys for the police officers. And then our individuals were able to ask a couple of questions.
Was this a deposition? Was it under oath?
It was simply an interview. It was basically a statement. It was not a deposition. It was if that was how we were going to get an officer statement, then that was the way we got it.
So it was
similar to an IA interview where we just ask questions.
So the questioner was an investigator employed by the attorneys for the officers involved in the shooting.
Yes, I don't know the man personally, and that predates my time, but yes, he was not a West Valley City employee, no.
But there was a West Valley City employee present, also allowed to ask a couple of questions in that interview.
Yes.
All part of the same interview. Okay,
Yes.
You referenced an interview conducted by an outside federal agency. Can you tell me which agency that is?
It was in conjunction with a joint investigation with the Department of Justice and the Federal Bureau of Investigation.
And the questions then were asked by a federal law enforcement officer.
Yes, and then some of our homicide detectives asked, but it was not part of the investigation at all.
Okay, so that is an interview that's not part of the internal affairs.
It would not be contained in that file, no, sir. But I addressed the transcripts because Mr. Carlisle had specifically identified transcripts. So those are the only two that there are.
So we have two interviews, the deputy chief's recommendation or adjudication, and the district attorney's ruling and letter.
Yes,
are there any other documents, I address this question to you and to Mr. Benderson, are there any other documents that are at issue tonight?
Since I have been requested to turn that over so he could give them to you, I'm going from memory, so I would just ask my esteemed colleague there to see if I missed anything.
This is Eric Bunderson again. Those are the documents that I have in my possession for the council to review.
Okay, thank you. So, Mr. Benderson, of these documents, what, if anything, has not been turned over as part of civil lawsuit discovery?
The deputy chief's adjudication and the I'd have to check. I'm not sure if the interview has been turned over or not.
One or both interviews?
Both interviews. I'm not sure if both interviews have turned over. Well, okay, the FBI interview has been turned over for sure, and I'm not sure if the interview discussed at the attorney's office was turned over. But now that I think about it, it has. So everything but the deputy chief's adjudication. Now, on that note, Councilman, the civil case does have a protective order attached to it.
Okay. Does the protective order prevent the city from providing those documents to newspapers or other sources?
Absolutely. Yeah, the protective order keeps all parties from disclosing those.
So are we barred from disclosing these under grandma even if we wanted to because of the civil suit protective order?
I would have to look into and read the specific language of the protective order, Councilman. I don't feel qualified to answer that immediately. I'd have to look into that.
So if we were,
and ask our outside counsel who's trying the case as well.
And if we were inclined to grant the grandma request, we would have to do so, except as may be prohibited by other court orders.
That's correct.
Okay. So this case seems to be similar as if Mr. Officer Salmon had died in the intervening time and we were not going to proceed with any discipline or any investigation because there's no point in doing so because we no longer have any authority to discipline him. Is that correct?
We would not be disciplining him, no.
Okay. And does the grandma statute provide for maintaining a record as protected when the investigative agency, West Valley City Police, District Attorney's Office, whomever, has decided to no longer pursue an investigation, that they've started an investigation and decided for whatever reason to stop investigating?
I believe that it doesn't Grandma doesn't give you that type of depth that you would be looking for, but it does indicate that it does allow you to make your choices appropriately, and it does specifically indicate what might be deemed to be public, which is the sustained findings when all appeal times have run. And I would just add, while I have just a moment here, that under the Grandma provisions, it specifically covers subpoenas and other court matters of discovery, and it indicates that discovery in those matters is not considered to be a Grandma type of a request. And then, of course, the protective order would have been entered with the court.
Well, but I mean, our ruling will be subject to whatever protective order there is. We don't have to worry about that.
I leave that to Mr. Bunderson.
So if an investigation has been initiated, you're taking the position that unless discipline is actually issued, that those records would never become public. They would always stay protected. Is that right?
If it's just, yes, if there's no sustained findings of misconduct, the reason for that is to protect people from spurious allegations that are made. If you just then give those out, it's very difficult to offer protection to an employee who may not have had any wrongdoing whatsoever, but an allegation that was not sustained goes out, and you can't unring that bell. So that makes it still allowed to be protected.
If an officer is investigated and then completely exonerated, that record has to remain protected. It cannot be made public to show that he was exonerated.
That would be our position, that investigative files do not go out, because you can be exonerated, but some of the charges would still be sensational or could compromise that person's integrity, put him or her out in the public way for no reason after it has been determined to have no merit. The other issue, while we are there, sir, is that the people that are brought in to talk to Internal Affairs about these allegations, and let's say the allegations that aren't ever sustained, those people come in and they are basically required to answer questions, whether they're a witness or a subject officer, under garrity, under threat of possibly losing their job or receiving discipline. And so they basically come in not 100% willing, but they understand that that's going to be something they have to do. But to have them then put out in the public way with basically dealing with things that aren't going to be sustained or what have you, it does have a chilling effect on getting to the bottom of a case.
Certainly those who are employed by the government and have the public trust should be required to account for their actions and should be expected to tell the truth, and should know that going into that employment situation, that this is part of the job to protect and to serve and to be forthright and forthcoming with all information regarding their discharge of those duties. And you mentioned in I wrote down some notes when you were giving your statement that these records cannot be released because of possible speculation or conjecture or difficulty for the officer. Are any of those words or phrases used in the statute governing the classification of these records as protected?
Well, I think that comes from the idea that it can compromise an investigation if things are going to go out before they've even had an opportunity for a full investigation. Things of that nature can, the chilling effect. Certainly the unwarranted invasion of personal privacy, if You, a police officer in today's climate, you're just called in to answer some questions. If then your name is out there simply because your employer called you in and said you might have seen or heard something, if that goes out prior to an investigation being completed, it could have a problem.
What if your name is out there because you shot at somebody and then the agency that employs you decided to terminate that investigation without concluding it and without releasing the findings to the public and what you said, whether it's exonerating or condemning?
Well, that isn't necessarily the case here, because those people have moved on. And we don't have the opportunity to finish it. We left it in the status that it was. So that's how we classified it, and there we are.
Classified it as protected while we were conducting an investigation. We stopped conducting an investigation. The newspaper has the burden of, by preponderance of the evidence, to say that the public interest, the public the public interest outweighs continuing that restriction, which was made solely for the purpose of protecting the integrity of the investigation while it was ongoing, which has now been concluded, not concluded with a determination, but certainly as those records are released, everybody would know, or if they inquired, would be told that the investigation was not concluded because Officer Salmon left the employee of West Valley City.
To the extent that your reasoning applies to what West Valley City had control of, yes, with respect to the federal agencies, we have no idea where that investigation is or what they are doing with it.
Do we know if the investigation's ongoing?
No, we do not know that.
Why is it that we have their investigative document in our file? Was it so that it would help us with our investigation of Officer Salmon?
That predated me, so I wouldn't be able to answer your question.
Was there any other reason why we would have their interview in our file other than to support or provide information for our own investigation of Officer Salmon? Is there any reason you can come up with why we would have their interview in our file other than with respect to our ongoing investigation of Officer Salmon, which is now concluded?
It raised issues concerning the shooting, and so it was perhaps useful since one of the shooting investigators asked a few questions.
Do we know any crimes that the Department of Justice, the FBI may have been investigating, and what the applicable statutes of limitations are for those?
They did not make that privy to us.
I think I'm done with my questions for now.
Thank you. Further questions? Councilman Rushton.
Yeah, the last one I just wanted to follow up on was something that Ms. Stoneberg had brought up, that, you know, this protected under ongoing investigation, and there might be some type of federal type thing going on. The mayor wisely pointed out that other interested parties could come in this, so I guess my question to Mr. Bunderson is have we heard anything from any other interested parties vis-a-vis the FBI or Department of Justice regarding the dissemination of this information?
No, we have not.
And would it be reasonable to assume that if they did have an interest in this, that they would reach out?
I think that would be a reasonable assumption, yes.
Thank you.
Mayor, I have a follow-up question to Mr. Rushton's question.
Councilman Bueller.
When the interview was turned over to us by the Department of Justice, were we instructed in any way regarding its dissemination? Now, at that time or in the future?
Eric Bunderson again, city attorney. When we were given the recording and the transcript of the federal interview, it was disclosed to us as part of as part of the ongoing investigation, which at the time was all considered protected and private. There was nothing specific accompanying that transcript or recording where the federal government, you know, wrote in a letter saying keep this private.
Mr. Salmon would probably be an interested person, but has he made any statement or any request of the city or city attorney's office with respect to these records?
No.
Thank you. And further, well, I do have a couple of comments. Of course, you come to expect that. You said that the investigation wasn't completed.
That's true.
Okay, what does that mean? I mean,
it means
was it
that the
10%
chief
completed, 99%?
It means that the police officer, prior to discipline, did not have a pre-disciplinary hearing, and that the chief did not render a final decision in the matter.
So it has nothing to do with the quality of the information, the clarity of the information, whether it would damage the individual or anything like that. So it only has to do with that the decision was not made.
Well, and that would have encompassed Mr. Salmon's due process rights, that he didn't have a chance to come in and speak to whatever issues were concerning the chief.
Now, these things have been going on for a number of years. Certainly police officers are very much in the light, very much in the news. Everything they do is second-guessed. I understand that. But I also understand the right of the public to get information. So I'm a little confused as I look at this issue and I say, okay, why aren't we giving it out? If a department declares it uncompleted, you'd never have to release anything. Or if you say to the individual, well, if you'll just resign, we won't release anything. How does that then square with the concept of providing transparency to the public? And I don't want to harm someone because of speculation, but I'll be pretty candid with you. You release the whole file to the media, they're not going to publish the whole file. They're going to pick out the most sensational part that causes people to buy their newspaper or listen to their radio program. They don't do it, quote unquote, fairly. They do it to provide information on certain pieces, and that could very easily, and has in the past, caused damage to police officers. Does that then justify us never releasing anything because the media could do it based upon certain pieces of what they show? It's kind of like the Rodney King incident. That was videotaped. If you watch the whole thing, you got a very different story versus what was shown on the media. So I'm trying to reconcile within myself how we meet this transparency need and being fair when we're using a partially completed file as the reason for not doing it because it might damage an individual. Now, if there is something in there that is abundantly clear that it would, then we ought to be told that, even if we have to go, what's it called, in camera?
Camera,
redact. Yeah. Then let's take that piece out and release the information. I guess I've been looking, well, I'll get in trouble, but then I always do. That's okay, I say what I think. Personally, the request I thought was kind of a little disjointed, and I didn't really understand other than transparency was the only requirement, and it was hard to connect all of the technical jargon with, you know, why we should or shouldn't release that. But the same thing has happened here. I'm not getting a clear picture. The one question I have to answer is, should this be released? And if not, why not?
And we have basically said that it would interfere with the internal affairs investigative processes, with investigations, so that something needs to be finished. If it's finished and is sustained, then Grandma says that is public.
Just because it's unfinished. Well, I guess I'm confused because certainly we've had police officers in our city for the full history of our city, and police officers have been around a long time. Grandma's been around for a while.
Yes.
This is not a new issue. So give me the compelling reason why, if we don't complete an investigation, why that shouldn't be released. Anyone can misinterpret it even if it's completed. The same data will be in there. Would not this exact transcript be in there if it were completed?
Yes, but yes, it would be in there. Not the FBI portion of it was not part of the internal affairs file.
Okay, but even there, I mean, I have to have a reason to either vote for or against this, and so far I've not gotten either. Other than the general concept that we should be open and transparent. Okay. So we release it if the investigation is complete. We don't release it if it's not complete, but it's the same record. You don't go in and modify it or change it or redact it or anything.
But up to this point, we have not given internal affairs files over the various testimonies of these officers who are compelled to speak. We give the final result that tells the
So you never
story.
release these kinds of files even in a completed investigation?
That's right. That is the position, and we keep it under that protected status. Yes, sir.
Okay. Well, now that starts to make a little more sense. If these are never released, it doesn't.
Oh, sir.
The issue of completed or not completed is immaterial. Is that what you're saying?
Well,
it has no bearing on the case whatsoever. Whether it's completed or not completed, we don't release those files.
That would be the
Right.
position of West Valley, but I was trying to show you the difference between this file and, for instance, the Deseret News that you were asked to review by Mr. Carlisle. That one was a completely different matter. There was even a written decision, and here there was no such thing.
Well, I guess what I'm saying is, if our policy is correct, we follow it consistently. That makes sense to me. And if that hasn't been challenged before, why would it be challenged in this case? Either we were right before and we're still right, or we were wrong before and we're still wrong.
That would be your decision to make, yes, but we do not give over IA files because of the chilling effect.
That helps me. That helps me understand, because the issue is, should we release those files? We've never done it before. And it's never been challenged.
No.
But now it is being challenged, so the question is, should we change our policy because of the impact it would have on investigations and upon individuals?
And rather than saying, sir, that it's a fixed policy, I would just clarify by saying we still look at the documents. So for instance, I gave him the resignation letter, I gave him the PSRB finding, I gave him some of the things that I felt could fit within the public realm. If there's a decision where discipline is entered, we give that over, but not the underlying file.
But that's the same information that you've always been giving out.
Yes.
So there hasn't been a change here. So we're being consistent in what we're doing. Okay. Looks like Councilman Bueller wants to.
I'd like to comment on that, Mayor, because our policy is and should be and must be to follow the law. And I asked you if you could point to anything in the statute that says we would maintain this record, these, including the interviews, as protected based upon a potential chilling effect on future investigations and officers being forthcoming, and you declined to state that that phrase, that word, was used in the grandma statute. It's not there.
No.
And the reason that we would maintain these records protected, we're hanging our hat on as a city because of the ongoing investigation, which is no longer ongoing. It's been terminated because we have no authority to discipline, so we're not going to continue to investigate. So that these documents would not be released because of a chilling effect or because we don't do it isn't consistent with grandma.
Well, our interpretation of that would simply be that the grandma provision that we use when we're talking about these things, it says if it reasonably could be expected to interfere with investigations or proceedings. And so we would say that those chilling effects and the statements going out under Garrity and what have you also would have an impact. That would impact the future.
Well, and with all due respect, I just can't believe that release of Mr. Salmon's interviews would prohibit our police officers, our sworn officers, from telling the truth in the future and future investigations. I don't find that as a compelling reason at all to keep these documents.
Well, I didn't say that they would not tell the truth.
No,
I don't.
Isn't that
I
what
just
chilling
don't want.
is? It's chilling. It means that they'll be scared and they won't do what they're supposed to do. They won't tell the truth. It'll hinder future investigations. That's what your argument is. If it's something different, explain it to me.
It may make them feel that that they will have no protection, that they will just have spurious accusations, and everything will be released irrespective of whether they get due process or not. And so those are the reasons. It's for you to evaluate our reasoning. Yes, sir.
Okay, wait a minute. Councilman Bueller, are you done?
Yeah, we're not getting anywhere.
Okay. Councilman Hyun.
Yeah. Ms. Stormbrook, I just encourage you to take a very strong position in this case. The reason, because you mentioned to me, you answer my question is you're not going to release this file in public because it conflict, not commitment. But you answer the question to the mayor is that even you can lit the fire, you still never release in public. So that's very contradictory. So I would love you to take a strong position in this one to make us very clear and send us a good signal. We can understand, we're not going to sit in here very confused. You know what I'm saying? Yeah, I would love to have kind of clarification for that and take a strong position, because you answered me different way and you answered the mayor another way.
And I'm sorry for that. That question seemed to be...
I know difficult for you tonight, but...
Oh, that's totally fine. That's why I'm here. I'm happy to answer your questions or do whatever I can. The issue with internal affairs files are simply this. They look into all kinds of allegations. They investigate the claims, whether they are valid or invalid, and then it anticipates that although the officers are asked under guarantee to come in and tell everything, they do feel that there will be some opportunity either for due process if they are the subject officer, that they are going to have that right. They're out there doing the hard things every single day, and yet they could lose their job if they don't come in and answer all of the questions. They do that. Other of their colleagues are brought in and questioned, and so forth. And then it's for the evaluation of the chief of police ultimately down the road to make his determination. If without letting that process run through the whole thing, people would never feel that they have a chance to get their full hearing themselves, their full investigation as a public employee. So that's the best way that I can describe it to you. This notion under grandma that it can be protected if release could have reasonably be expected to impact these proceedings. Well, it does. It does have that effect when you just put out the whole file.
Yeah, the reason is because I just want to have a clear answer so I can respond, or we can respond back to Mr. Nate Carlisle with the request tonight, and that's just the reason why I just want to say to you, you got to take a strong position and make it clear to us so we can get the right answer.
This is the position that the city has taken, but I will say separately to this that one interview that was done by people who flew in from the Department of Justice and the Federal Bureau of Investigation. We may have a copy, but that isn't what we would term our document. That belongs to another investigation that we are not privy to. something that could go on for a long time. Those types of investigations can open or go dormant, open again down the road. We have no idea. We've tried to get an answer. The FBI and the Department of Justice don't want to tell us the status of that. So to just then hastily put something out that could compromise something totally unknown to us, just because we sat in an interview and were given a copy, as Mr. Bunderson said, with understanding that it was just for our own information, part of that we were looking at, but we didn't instigate it. To me, that would indicate that record is not an internal affairs investigation. That's an investigation of another agency, and we cannot be the ones that give that over. If Mr. Carlisle wants to go and ask the FBI for it, they originated it. They came up with the reason, the date, time, and place, with people coming in from Washington, D.C. and who knows where to take over this. Now, that's a different story. Then they can answer these questions. They can make that weighing decision. They can say, when they put it in the balance, well, is our investigation here, there, or anywhere? That's for them to say. We've asked, we've been told nothing. So for us to just say, well then, here it is, that's not what we feel we should do. And that's where we feel, even though the minutia of filling in every little possibility isn't there, we believe, and I am telling you strongly, that I feel that that type of a hasty reaction, where we have but one piece, one transcript of something that's bigger than us, that's a federal situation, and then we give that over, that, sir, does have a reasonable possibility of interfering with investigations and the investigative process.
Well, Ms. Stonebrook, thank
Yes,
you
sir.
for tonight. Thank you for taking your time tonight.
Councilman Bueller.
Thank you. I want to make sure that I'm clear on your reasoning, Ms. Stonebrook. What I'm hearing is this. We can't turn over Officer Salmon's statement, because then he will not have had an opportunity to tell his side of the story.
That's true.
However, his statement, I would suggest, is his side of the story. He got to decide the answers to all of those questions, and he said what they were. And we expect that they were true then, we expect that they'd be true in the future, and we expect that he got to say what he wanted to say in response to each and every question that was asked of him, and that is what makes up and becomes the interview and the transcript of that interview.
Yes, we're not asserting that he did not answer questions truthfully, but as to the outcome of that, what people make of it, the chief never came up with that. He didn't have his due process on that aspect. There wasn't a final conclusion of whether it was sustained problems or not. He didn't get that chance. So it'll just go out there that...
As a clarification, I kind of interrupted you a little bit there,
sir.
but you were repeating what had been said before. The federal one, you don't know if that investigation is completed.
No, sir. I checked today.
So that's an ongoing open investigation. That seems, for that piece, for that document, reasonable justification to not release it, and that the inquiry or request should probably go to them until they tell us that their investigation is complete, that portion of it. That seems to make sense.
Well, and Mayor, I think we could deliberate now, or we could deliberate after our other two meetings. I mean, I'd be willing to deliberate now or after the other meetings in private, either way.
Well, certainly this is going to merit some discussion. And we still have some more to go on.
If we have more questions, we ought to have those asked.
Yeah. Well, remember that the process, we're going to have a, what's it called, a rebuttal? So we still have that. So you'll still have your opportunity. We haven't forgotten our process.
No.
So, yeah, there's a lot of issues. So I guess, have you asked your questions at this point, and do we now want to move forward with Mr. Carlisle's response?
Yes.
All right.
Thank you.
Thank you very much.
Questions.
This doesn't mean that we won't have more questions.
Thank you. Can I say a few things and I'll be happy to take questions? First of all, the issue with the FBI/DOJ interview. If the FBI didn't want West Valley City to have that for its benefit, it never would have given a copy to West Valley City. And if the FBI doesn't want it released now, there's been public notices. Ms. Stonebrook's reached out to them. All they have to do is say, don't release that, we're still investigating. We've heard nothing out of FBI/DOJ. And I would contend that there's no indication whatsoever that any investigation is still ongoing there, or they could tell West Valley City that. A few other points. There was some discussion of whether Mr. Salmon would feel his privacy was being violated. With all due respect to Mr. Salmon, his feelings are not the issue. There's actually quite a bit of case law on what constitutes a clearly unwarranted invasion of personal privacy. And this was also discussed in the Deseret News opinion, and Judge Dever addressed it in his ruling in the Lawrence case. And I would refer to those. Also, there was some discussion of whether the Tribune has to show some preponderance of evidence of whether public disclosure favors not releasing the record. This was addressed in the Deseret News decision and Judge Dever's ruling as well. They said that the public is best served by knowing about the performance of public officials in the discharge of their duties. And these documents in question tonight would get to that. Let me just go over a couple notes I wrote. Let's see what else I want to raise before I take questions, please. Okay. There were some what I found to be contradictory statements about the classification of these records and whether they were reviewed prior to the denials. On one hand, Ms. Stonebrook indicated there was a review, but then she was also saying that they don't release any IA files. It sounds to me like there wasn't proper review in that case. Be that as it may, I would remind the council that according, again, to the Deseret News ruling, that it has an obligation to do a fresh review, a de novo review, for those of you who are lawyers here tonight, of the records and make your own decision whether it should be classified as private protected or released to the public. Okay. Finally, there was some discussion of whether there'd be conjecture about what occurred or whether Mr. Salmon violated policy by releasing a unfinished investigation. I think there can be an argument made that the conjecture would really occur if no documents are released at all. Also, there's no discussion in the statute whatsoever of a finished or unfinished investigation. The grandma just talks about documents and records, and these are clearly records. No one's disputing that they're records. Just Ms. Stonebrook is raising the issue of whether the investigation was finished. I find that a moot discussion. Okay, and I'll be happy to take questions now.
Back to the council. Councilman Bueller.
And Mr. Carlisle, this isn't necessarily a question, but I would comment on your rebuttal. This body has refused to release records based on the statute because of an ongoing investigation. When that investigation was concluded, we did release the records. I would refer to the records in the Joshua Powell investigation. And we were happy to release those when we decided we had no more trails to follow and that the investigation was concluded. Here the question is really, this investigation was not concluded and will not be concluded. And I don't think that's explicitly covered by the statute, and that's where we have to exercise our judgment.
Councilman Hume?
Thank you, Mayor. I just, you seem like you're very a good reporter, very consistent. You know, you came here before.
Good night.
Yeah.
I'll end on that note.
I think my question, very curious question is, what made you interested in this case?
That's a fair question. We've heard from the other officer that was involved in the November 2 incident. He had a day in court. We've not learned a lot about Mr. Salmon's role on that day. We know that the district attorney decided there was nothing criminal about his behavior, but we don't know what Mr. Salmon told investigators. We don't know what West Valley City investigators found. And again, I find some inequity in that. Someone here made the comment that Mr. Salmon had an opportunity to tell his side of what occurred on November 2, and I'm eager to hear that, and I think the public is eager to hear that as well.
Thank you.
Thank you.
Councilman Rushton?
Hey, thank you, Mayor. I think that I've heard all the information that I need to at least sit down with our own attorney and ask some questions and deliberate some of the points raised with council members. So I would move that we, I guess, suspend kind of the fact-finding section.
Mr. Pyle, are we within our jurisdiction to take that action now?
You are. That's not what I'd recommend. If you could,
Well,
what I'd recommend is if, from a moving forward standpoint, you get through the other two meetings first, and because you're probably going to take a significant amount of time to talk about this.
Okay. Can you make the motion that following our next two meetings after we adjourn, that we go in camera?
Yeah.
And
yes,
have that discussion, and then make sure that our results, I think we have till next
Tuesday. Yeah, to actually issue an order.
May I ask a question?
I guess so, as part of your rebuttal. We don't have to answer it, but you can ask.
Well, there was some discussion of asking Mr. Bunderson to draft an opinion on whether a protective order closes some or all of these records. Is that still going to be undertaken? Okay.
I'm sorry, I don't have an answer for that.
Okay.
We're not going to violate a court order to give records.
And fair enough, but my position would be if Mr. Bunderson does come back with an opinion that a protective order covers this, that's not something I prepared to address tonight, that wasn't a reason listed for denial. I would like an opportunity to address that point if that's Mr. Bunderson's opinion. Now, if that means another hearing or continuing the hearing, then I'd be willing to do that.
Or perhaps would mean intervening in the civil suit to ask that judge to release the records.
Well, yes, that's an option, but first, what if, no offense to Mr. Bunderson, but what if I think he got it wrong?
Right, and that would be up to the judge to say, well, I don't mean to exclude it from the Tribune. So
well, but okay, but couldn't I take that? Why can't I take that up with you rather than the judge?
Yes, you could make another grandma request. I mean, I don't know. That's a good question. I mean, if you disagree with this, you have an appeal from this decision, don't you?
Well, but again, we're coming up with a whole new rationale for the denial at that point that I haven't argued here, I haven't briefed here. I think there's a due process issue if Mr. Bunderson comes back with that opinion.
Well, I'm not going to counsel you on what you would do. I guess you will have to make the decisions what you may do.
Okay, I'm not asking you for counsel. I'm asking, could I have an opportunity to address that point if Mr. Bunderson comes back with that opinion?
And I would say that that's a good point, and we'll take it under advisement under our deliberations, because I think really the purpose of this is to gather information on what we're going to take into deliberations, and not necessarily have to deliberate point by point. But I think if we get to that point, then in deliberations, we could say, yeah, this is absolutely a valid point, and maybe we need more information, and you have to reopen it, or you can say, absolutely it's not, and it has no bearing on our decision.
Maybe Mr. Benderson could access the protective order, and we could consider that as part of our deliberation.
Right, that's what I'm saying.
Well, wait a minute, before this gets into an internal debate here, the issue before us is that we have to rule on this, and we have to do that within the 1 week period, or next Tuesday. Even if additional issues, or if you bring up additional issues, we take that under advisement, but I think we're still bound, regardless of what issues have arisen or what other justifications may arise for release or not releasing, we still have to decide in that time period. I don't think we have the option of saying, oh, something new came up, so we get an extra week, or something like that.
I believe that's correct, but just to settle the question, I would recommend referring the question to Mr. Bunderson. I'm sure he can answer that.
In terms of the 5 days, that's correct. That is all the time that we have.
Yeah. So even though, I'm sorry, Fred, I
know,
I can't. Fred.
But earlier,
I'm sorry, Fred.
I know, but earlier he said that we would have opportunity for public comment. So I just thought it was a hearing. You'd have two sides and possibly public.
I'm sorry.
That's if you as a body would like to hear that. You're not required to take that.
Thank you. Okay. Yeah. So, but we're in the middle of a different discussion right now, and it's pretty clear that this won't be resolved.
That's why, there's no new information I feel to be gathered. So let's, I want to make the motion that, we go into closed deliberation at the end of our agency meetings, and we can have these debates and do that then, because I said we're spinning wheels, so I want to end it. And
okay.
I have, I've got my check box. So
is there anything else? Yeah. To make sure that the motion is valid, is there anything else that we have to do that this motion would cause us to say we didn't complete the process?
Eric?
So just going over the procedure again. At the hearing, the City Council shall allow the parties to testify, present evidence, and comment on the issues. The City Council may allow other interested persons to comment on the issues. So I do think that if there are other interested persons, they are at this point allowed to comment on the issues. That's a requirement under the ordinance.
Requirement that we may allow it.
That's correct.
Mrs. Stonebrook, for some reason I was thinking that was wrong, Martha. I'm sorry, but I know that's correct.
Okay. I've been called worse. Could I just clarify?
Well, wait a minute. We're in the middle of a motion, and we're trying to figure out that first. Okay.
Yeah, I'm sorry I missed that too, Mayor. I know we were talking about doing that. I'm not sure. I didn't hear that we actually had a motion. So
well, I made the motion. If there's not a second, then you can open it back up. But I would say somebody second it. Let's vote on it.
Because of clarifying the process, stopped in the middle of that. It is not my intent to prevent it. We didn't ask for the second yet. It was to clarify where we were and was that we were able to take that motion. And I've been told that yes, we could. Now, if the council disagrees with that due to a lack of a second or just a vote no, then we could still, if they want to do the public or having other interested parties participate, we could do that. So it's really up to the council. The council makes that decision. So we have a motion before us. Do we have a second? Councilman Bugh.
Mayor, in discussion of the motion, rather than second, I would oppose the motion. Want to hear from Mr. Cox, 30 seconds, what he has to weigh in on this fact finding as an interested party, because that I think it's incumbent upon us to receive all information that may be presented tonight before we go into deliberations.
And as I said, either for lack of a second or a majority no vote, but the motion is before us. And so, as chair, I have to deal with that first. Do I hear a second? And I'll give you about 10, 15 seconds. Motion dies for lack of a second. Okay. So we have now heard our presentations that we're required to hear. Is it the will of the council that we open it to public comment?
Aye.
Yes.
Yes.
Yes. Okay.
Can I also?
Yes, Councilman Nordfeld.
I think it'd be appropriate to hear from Ms. Stonebrook one more time, and Mr. Carlisle. I think she has something to say, and give him a chance to rebut that too. But maybe we should hear from Mr. Cox first.
Well, that was what we were going to do next, and then it's up to the council whether we need more information. There tends to be a lot of repetition in some of this. So, to the public then, is there someone here in the public who would like to comment? Now, Mr. Cox, Representative-elect Cox, please come forward.
Thank you.
Thank you.
I'm not an attorney, but I do know a little bit about grandma, and I have been reading some of the statutes as you've been discussing. Just one comment. The Desert News ruling predates 2012 SB 117, so the law has changed since then. Don't know if that affects a decision or not. If this decision is denied, obviously the reporter has an opportunity to appeal to the Records Committee or to others. If an officer or other individuals are required to testify without the ability of taking the Fifth Amendment, which I believe happens in these cases, I think that's another thing to take into account. You have a record where someone may be testifying against themselves, that in a court of law that information would not be allowed. And then the final thing I just wanted to pass on as a comment is 63G2305. Your attorney has been quoting A and B regularly, but there is C, D, and E in that section. I would ask you to read the rest of that section, because it talks about, if my battery doesn't die, would create a danger of depriving a person of the right of fair trial or impartial hearing if there's possible suits out and there is information that would not be able to be released in a court, but you have it. You might take that into account. Reasonably could be expected to disclose the identifier of a source who is not generally known outside the government. So if these records have sources that are private sources, and otherwise everybody doesn't know who said that, there is the potential that you have the right to keep this a protected record, in my opinion. And then the final thing I wanted to comment is E, is reasonably could be expected to disclose investigated or audit techniques, procedures, policies, or orders not generally known outside of a government disclosure and would identify with enforcement or audit efforts. Anyway, I'm just saying, you're reading A and B, read the others, because if you've got an FBI investigation that shows who investigates, how they do things, you may have some additional reasons to consider the request or not. But I just get nervous when someone quotes a statute and doesn't read the whole thing. And I just thought I'd pass that on. I'm not saying that you should or should not release the information, but I just think that there are some things that you might consider. Thank you.
Thank you. Is there anyone else who wants to comment on this from the public? We'll come back to council in just a second. I'll make sure I get... No one else? Okay. Now back to the council. Councilman Rustin.
I'll play ball. Mr. Bunderson, since this is kind of a fresh review of this, should we be taking into account sections C, D, E, and F that have not been brought up, by the city as reason for denial?
It's a very good question. The ordinances and procedures and statutes don't contemplate one way or another, but the case law would seem to indicate that you, as the council, are, as we've mentioned several times, looking at these documents de novo. And so if you wanted to read the entire statute, and as you look at these, I think that would be appropriate, although I have to say that's not ever been litigated in terms of any case law that we've seen. Thank you.
Council, would you like more information, more testimony from the interested parties? Councilman Bueller.
Mayor, I move that we determine concluded the information gathering aspect of this hearing and close the hearing and enter into deliberations following the meeting of the RDA and the Housing Authority.
Second.
Motion's properly before us. Discussion? Councilman Nordfeld.
I think that that we should give as much information as we possibly can. I know we've heard things repeated many, many times, but I've seen Mrs. Stonebrook raise her hand and say she needs to clarify something. I'd hate to go deliberate thinking that I might have more information that I'd like to hear. So I speak against the motion.
Okay. Any further discussion? Seeing no further discussion, we'll place the motion for a vote. All in favor of finishing this meeting, having our 2 short meetings for, what's it, Housing Authority
and the RDA,
or redevelopment, and then going in camera to have our private discussion, say aye.
Aye. Aye.
Those opposed say no.
No.
Okay, we're going to have to do a roll call because I didn't hear everyone.
Mr. Vincent?
No.
Mrs. Lake? No. Mr. Bueller?
Aye.
Mr. Hughes?
Yes.
Mr. Rushton?
No.
Mr. Nordfeld?
No.
Mayor Bigelow?
No.
2 yeses and 4 noes.
I'll say. So, given that, Councilman Nordfeld.
May I suggest that the attorneys be brief and don't repeat information we've already heard?
Okay. With that, we've had in our rotation, next would be Ms. Stonebrook, and then Mr. Carlisle.
Thank you all for your time tonight. I certainly appreciate it. It's Martha Stonebrook with West Valley City. I'm only wanting to clarify 2 points that Mr. Carlisle made. He seemed to believe that that I reached out to the FBI and the Department of Justice today. I did not do that. I did check on the status of the investigation with the administrators of the police department who would know that information. I don't have them on speed dial, and so I wanted that clear. And as to just doing a rubber stamp, we just don't ever review the file and just deny everything. Mr. Carlisle knows that in fact we have released things to him that have come from internal affairs files that fit within the definitions that fit as public information. He's received those on many occasions, and I just wanted to clarify that we do look at each file. We feel that they fit in one category more often than others, but we do release pieces of it that we feel are public, and we have done so to the Salt Lake Tribune and others who have requested material. Those are my only 2 clarifying points. Thank you all.
Okay, thank you. Mr. Carlisle, any final comments?
First, just so I don't have to pay dues to the Bar Association, I'm not an attorney, but thank you.
So you're aware there's only one attorney on the council.
Yeah. Is he okay?
You have to guess which one.
Well, I know. Let's see. First, just a reminder that Grandma says records in Utah are public unless the law expressly says otherwise. Mr. Cox raised the issue of whether or not Mr. Salmon had council or whether or not he was allowed to take the fifth or compelled to give testimony. That's not discussed in the statute. And so I don't see how we could weigh a factor when determining whether these documents should be released. That is all. Thank you.
Thank you very much.
May I renew my motion without restating it? If so, I'll renew my motion.
Second.
Okay, now wait a minute. If a motion has been defeated,
can we ever close?
I don't think you can well, if they introduce the same motion, then I'm not sure you can you?
No, at the risk of not being known as the Robert's Rules of Order expert here, but I believe the rule would be you either come up with a new motion that's different, or you have somebody who voted against the motion bring up the motion.
Well, if someone who voted against it brings it up again and wants us to reconsider our action,
yes,
then we could. But you can also do it by changing the motion so that it's different. So, someone wants to try that, the chair will entertain that. Councilman Nordfeld.
Mayor, I move that we renew the motion that was voted on before.
We reconsider our action on the previous motion.
That's what I mean.
Okay. That motion is before us. Do we have a second?
Second.
Okay. The motion before us is that we reconsider our action on our previous motion. And having voted on the prevailing side, didn't you? That is in order. So, all in favor of reconsidering our action on the previous motion, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. We are back to that point again. The motion is, I believe, now before us in its previous state by reconsidering our action. Or no, I take it back. If we reconsider our action, that means that there's nothing before us, so we need to reintroduce a motion. So, now,
I move that we close the fact-finding portion of this hearing and enter into deliberations following our RDA and Housing Authority meetings.
That motion is appropriately before us. Do we have a second?
Second.
Now before us. Any further discussion? Seeing none, we'll place the motion for a vote. All in favor of the motion to close our fact-finding portion, continue on with everything else, and then concluding all our meetings, we go in camera to, I think that's the right term, I'm learning the legal term, to have further discussion in private. All in favor of that motion, please say aye.
Aye.
Those opposed say no. Motion passes unanimously. So we have finished with that portion, and we will begin our deliberations. And for those of you who attended, we will have a response within the 5 working days. I guess it is next Tuesday. Okay, thank you. Ben, that concludes our agenda items. We have no need for an executive session, so I would entertain a motion to close the regular portion of our business, our council meeting.
Motion to adjourn.
Motion to adjourn is in order. All in favor, please say aye.
Aye.
Those opposed say no. That passes unanimously. We are adjourned. We do have 2 housekeeping meetings that we need to take care of.
I call to order the regular meeting of the West Valley City Redevelopment Agency. Now we have an opening ceremony and all board members are present. Item 4 on our agenda is the approval of the regular meeting minutes that we held December 2nd, 2014 for your consideration.
Mr. Chair, I move we approve the minutes.
Thank you.
Second.
We have a live motion before the body to approve the minutes of December 2nd, 2014 as written. All in favor, please say aye.
Aye.
Any communications to report tonight?
No, sir.
Okay, thank you.
You should stay there.
I did. It passed unanimously.
Motion to adjourn.
All in favor of adjournment?
Aye.
Stands adjourned.
Call to order the West Valley City Housing Authority. Note that we've had an opening ceremony, that all members of this body are present. We have before us the minutes of our December 2nd, 2014 meeting. To the Housing Authority. Mr. Northville.
I move that we approve the minutes of December 2nd, 2014.
I second the motion.
Thank you, Mr. Bigelow. We have a motion and a second. All in favor of approving the minutes, please say aye.
Aye.
Aye. Any opposed? That motion passes unanimously. Mr. Powell, any communications report or other business tonight?
No, sir. Thank you.
And a motion to adjourn would be in order.
Motion to adjourn.
All in favor of adjournment, please say aye.
Aye.
This body is adjourned.
Okay.